All rise. Circuit Court of Rankin County is now in session. The Honorable Henry Arthur presiding.
All right, please be seated. Let's see. Okay. All right, Stan, Mississippi versus Carly Gregg, cause number 2024-34169. Please bring the defendant to the podium.
All right, pause here. This is where things get serious. A pretrial conference might sound boring, but this is the moment where life-altering decisions are locked in. This isn't about guilt yet. It's about choices, leverage, and risk. And trust me, the risk here is massive.
All right, we're here by way of pretrial conference checklist, which means that the defendant has rejected any recommendation from the state.
Let that sink in. 40 years offered by the state. That's not a casual number. Prosecutors usually don't start there unless they believe they've got a strong case. So the real question for you watching, would you gamble on a jury or take decades behind bars off the table right now?
For the record, what was the last recommendation of the state of Mississippi?
Here, the state recommended 40 years in the custody of Mississippi Department of Corrections and agreed to not cross counts 2 and 3 of the indictment. Again, there were fines and no contact and things like that.
All right, Ms. Gregg, did you receive that recommendation of 40 years?
Yes, sir.
And it was your choice and your choice alone to reject that recommendation?
Yes, Your Honor.
You know, if she proceeds to trial, count 1, what's the potential sentence?
Life.
If the jury fails to affix the sentence at life, what's the sentencing range?
20 years to 40 years.
All right, and count 2, what's the potential sentence?
This is one of the most chilling moments in the entire hearing. The judge is laying out the math, cold, clinical, unavoidable. 2 life sentences or up to 93 years. This isn't dramatic language. This is the legal reality. And remember, the defendant is only 14 years old.
Between 20 years and life.
All right. She's 14 years old, so if the jury fails to affix the punishment at life, she's facing 50 years?
Give or take, Your Honor, yes.
Okay. And in count 3, what's she facing?
Another 10 years.
Here's where procedure becomes power. Expert reports aren't optional. They're required. When one side doesn't comply, it can derail timelines, weaken credibility, and even trigger sanctions. This tension? That's not accidental. It's pressure building before trial.
Another 10 years. So the jury will either acquit you, or you'll be facing 2 life sentences, or this court can sentence you up to 93 years. Do you understand that?
Yes, Your Honor.
It's your choice and your choice alone to proceed to trial.
Yes, Your Honor.
Have a seat. It says discovery is complete except expert reports from a non-experts. I thought I've ordered that those be turned over 3 times. Has that been received by the state?
No, sir, Your Honor. And I just, before you walked in, got with counsel opposite and showed them 2 orders that were motions that he granted last time we were in front of you. The order granting our motion to compel their compliance with the mental evaluation analysis, and also the order granting the motion to compel compliance with Rule 17. May I pray?
Do you still intend on trying to offer experts at this trial?
This might sound like a joke, but it's not. Jurors get paid $25 a day. The judge is warning both sides. Don't waste time. Don't play games. Courts remember who drags cases out, and it never helps your credibility.
Here we have an expert that's going to be doing an evaluation. We do not plan on contacting him.
All right. Well,
And Your Honor, just for the clarification, we're aware of the time constraints, and we know that we have to get our evaluation done. Our evaluations happen on Thursday. And the report-
Actually, the reports were due a month ago, Mr. King. I signed an order more than a month ago. Now, I'm not going to, there's nothing in front of me to rule on at this time. There's nothing in front of me to rule on at this time. All right. Says that there's some pending motions, anticipated motions, to suppress urine test, and both sides think it'd be 3 days for trial. Is that correct by the state?
Your Honor, I believe it'll take probably a little more than 3 days. But there are additional motions that the state intends to file, certainly some motions in limine.
All right. By the defense?
Your Honor, I expect the trial itself to probably take 4 to 5 days.
All right. I'll remind both sides these jurors are getting paid a whopping $25 a day. So y'all drag this case out at your own peril. However, I'm going to give each side plenty of time to try your case. All right. All motions under Rule 16.1, the motion filing deadline is this Friday, August 30th, 2024. Under Rule 34.1, the Mississippi Rules of Criminal Procedure, all motions must be in writing and must contain a concise statement of the precise relief requested and must state the specific factual grounds and specific legal authority. Failure to comply will result in the motion being considered procedurally abandoned or waived. Responses must be filed in writing before the close of business Wednesday, September 4th, 2024, or the motion may be considered confessed. Reply to any response may be filed if desired before the close of business on Friday, September 6th, 2024. Under Rule 34.2, you must be in court on Tuesday, September 10th, 2024 at 9 o'clock for hearings on pretrial motions.
And here's the final setup. Everything now funnels into pretrial motions. This is where cases are won or lost before a single juror is sworn in. Evidence in, evidence out, strategy locked. So tell me, based on what you've heard so far, would you risk trial?
All jury instructions must be pre-filed before the close of business on Friday, September 13th, 2024. This court will not entertain a request for jury instructions. Either party failed to pre-file unless there is good cause shown. Additionally, an editable copy of all instructions must be emailed in Microsoft Word format to sbutler@rankingcounty.org. All right, I need this attorney for the state. I've already signed off on this.
Yes, sir.
Oh, my God, yeah.
Do I need to put the additional motions?
No, as long as the motions are filed by the motion filing deadline, the court's going to consider all motions both parties file. As long as they contain a legal basis and, some case law. All right, anything further from the state?
All right, I think the only pending matter, and this may be something that we address at the pretrial conference, is the defendant, and I don't have it in front of me, I think filed a motion to transfer to youth court that we've never heard.
You want to hear that on pretrial conference day, or do you want to hear it today?
Pretrial conference day.
All right, the court will hear that matter on pretrial conference day. Anything further from the defense?
No, Your Honor.
Best of luck to both sides. The defendant will remain in custody to await trial. Yes. All right. Court will be in recess for 15 minutes.